Hello, my name is James Lee. I'm an attorney at Liberty Law. I do personal injury and criminal defense. On this channel, we talk about the cases that shape Utah law. Now, the case today that I want to talk about is Gardner v. Norman. If you're a personal injury attorney, I'm sure you heard about this case by now because it affects the daily practice of law. Now, the issue that this case addresses is when a health insurance reduces a bill for you, what are the medical damages? Is it the original bill that the hospital charges, or is it the lower amount that the hospital chooses to accept? Now, the facts of this case are simple. Basically, Gardner and Norman get into a car accident. Gardner goes to the hospital and he incurs a bill of $10,000. Now, the $10,000 is paid for by the health insurance, but obviously they do not pay the full $10,000. They only pay $6,000 because, as most health insurances have in place, there's a contractual agreement already with the hospital that they will pay a certain amount. And in this case, $6,000 they're going to pay, $4,000 is written off. I'm just using round numbers, by the way. So $4,000 written off, and then Gardner claims the full amount of $10,000 as his economic damages or special damages. But Norman, the defendant, says, hold on, why am I going to pay the full amount of $10,000 when Gardner didn't pay it, nor did the health insurance pay it? Now, that's a pretty reasonable question, and what he's asking is, and this goes to the collateral source rule. So for the PI attorneys out there, you know what the collateral source rule is, but for the non-PI attorneys, I'll explain it really quickly. So the collateral source rule is when there's a third party who pays your bill. And the fact of that cannot be introduced to a jury because it's believed that that will prejudice a jury, in that the jury may think that since the bill was paid in whole or in part, that we don't need to award the plaintiff as much money. Now, there's a part of the collateral source rule, there's a nuance that has not been addressed, and that is this contractual adjustment, the amount that is written off. Now, in the past, what we've always done is we point to the $10,000, the full amount, and say, collateral source rule, we are allowed to use that as a starting point for how much economic damages there are. The adjusters and opposing counsel have challenged me on this, but most of the time I can just point to the collateral source rule and say, hey, look, this is what the full bill is, and these are the economic damages. Defense attorneys for many years have said that this is not right. The defendant should not have to pay all of these bills because that is not actually what the plaintiff or the health insurance paid. And in this case, the court sides with the defendant. They say that the collateral source rule does not cover adjustments. Now, is this the right decision? As a personal injury attorney, of course, I am naturally inclined to side with the plaintiff. And in this case, I do side with the plaintiff. I guess it's not a surprise. And this is my reasoning. And a lot of this stuff is talked about in the case, so it's not all my original thoughts. But my thought is that Gardner, the plaintiff, he paid for insurance. So I believe he deserves the benefit of that insurance. And if the benefit is a negotiated price, then so be it. Maybe a good way to illustrate this is to take more exaggerated numbers so that this is more understandable. Now, let's say we go into the hospital to get a surgery, and this is from a car accident. And the surgery costs $100,000. Now, I believe that $100,000 is an accurate representation of the magnitude of that accident. But the thing is that Medicare might come in, and this is very common. Medicare or Medicaid comes in and pays only $10,000 of the $100,000. So $90,000 of the bill is written off. Now, is that $10,000 for the surgery an accurate reflection of the magnitude of that injury? I don't believe so. Now, another way to look at it is, let's say you have two people. Two people get into an accident, they have the same injury, they have the same treatment, and they both get the same bill of $10,000. The only difference is that person A has health insurance, person B does not have health insurance. Person A gets an adjustment. So his bill is now $6,000. Person B doesn't have health insurance, so his $10,000 bill remains as $10,000. Now, that doesn't make sense to me, to have the exact same injury and treatment, but yet have two totally different outcomes in what the special damages are. The way the court distinguishes this scenario is that they just say it's the luck of the draw. You take the plaintiff as you find them. See, I don't see that explanation as very satisfying, because it doesn't go to the heart of the issue here, which is, the economic damages of what the plaintiff experienced. Now, there's a good thing about this case, and that is the collateral source rule is not abolished. It still exists. The fact that a third-party payer pays your bill, that still cannot be admissible. And the other good thing is that the gross medical bills, the court didn't say that it was never admissible. So the way I understand that is you could still use the gross medical bills to argue for non-economic damages, general damages like pain and suffering, or for future damages. In my practice, I know that things have changed in the last year. The negotiations I've had with adjusters have changed. They are now asking for health insurance ledgers, for final subrogation amounts. And so if there is economic damages of $10,000, it used to be that the starting point for negotiations was $10,000. But now, if that $10,000 is partially paid by insurance, the starting point for negotiations ends up being a much lower amount. Now, in my practice, what I've seen is we've been litigating more, and I imagine that's what's going to happen more in the future, because with adjusters, they just go based on the numbers. They got their marching orders, they get the numbers, they put it into a computer, and then it spits out a number. They're not looking deeply into a case to figure out, what is behind the actual medical price that comes from the hospital. So with litigation, you're talking face to face with an attorney, and you can talk more in detail about what the numbers represent. So in summary, the case is pretty much about a plaintiff can't recover gross medical damages that neither the plaintiff nor the insurer were ever obligated to pay. But that also doesn't mean that the collateral source rule is gone. It's just that the collateral source rule has been narrowed in its application. And that's Gardner v. Norman. Thank you for watching.